Good evening, all. We warmly welcome you to this legal discussion on child adoption and custody, a part of Phase 8 of Law is Right of the Pro Bono Committee of the Law Students Association, Sri Lanka. We are honored to have with us today as our speaker, Ms. Milani Salpiti-Kola, a well-experienced attorney at law with a demonstrated history of working in the legal industry, specifically in the fields of conveyancing, legal writing, corporate law, corporate governance, and legal research. She specialized in child rights and human rights law from the Queen University of London with a wide-ranging experience in family law. She is the founder and the executive director of the Child Protection Force. She's also serving as a lecturer at ICLC campus in Sri Lanka for public law and family law. It's a pleasure to have you with us today, madam. And we are streaming live on Facebook. Feel free to send us your questions, and our speaker will clarify those questions at the end of this session.
It's 18 hours.
Hi, thank you so much, Shalomi. And thank you, Z, for inviting me. It's amazing to see young students, young lawyers, sharing knowledge with the public, with the rest of the fraternity on matters that are, how should I say, these are real life problems that need to be discussed and things that people need to know. So I am thankful for being invited, and I hope I serve you justice today.
Thank you for being with us, Miss. Miss, could we begin with an introduction to the work you do and the importance of child protection laws, because there are law students also watching this as well as the general public. So if you can give like a balanced answer that caters to both set of public and the law students.
Okay. So I'm going to just give you a tiny introduction of myself and why I'm here today. I never wanted to be a lawyer. I wanted to be a veterinary surgeon, but by default, I think how some of us become lawyers is by default through family influence. So that's how I became a lawyer. But I started working for Justice Shirani Tilakawardena, who is a massive advocate and activist for child and women's rights. So that is where my passion started initially for child rights. And I started doing a lot of research. And I thought, look, okay, this is where I'm going to study, because I did a research in 2000, anyway, long time ago, in 2012 or so, about children within the justice system. So these are victims of abuse, and also children who have been accused of offense. And through this system, I did it with late attorney at law Sajiva Samarnayaka, who is also my guru. Through this, we found that a lot of children, there are court cases pending for a long time. So some court cases that have been going on for 15, 20 years without any recourse. And the child doesn't know what's happening. The guardians don't know what's happening. So this is where I thought we need a little, kind of retweaking, a little oil here and there, and, get it running. So that is where I thought I will start a project on to try to expedite this whole system of child protection within the justice system. So I know there are quite a lot of young lawyers, law students who are extremely interested in this area of child protection, women's rights, human rights, but also these are not paid well. Okay, because most of the time, the client, who is either the victim or the aggrieved party, they don't have enough means to hire a lawyer who is, who is going to charge them. So this is where I feel a lot of lawyers and a lot of students back out because it's not paid well. But the satisfaction of what you achieve out of one case, right? I mean, there's one of our cases where a child was subject to severe secondary victimization through the system. And once it came to us, we started looking at what went wrong and, put out a plan of action and started writing to the relevant departments, because it is not only yourself being a lawyer who is a counsel going to court, right? It is yourself being a lawyer representing your victim physically, not only in court. So you will represent your victim at the police station, you will represent your victim at different government authorities like the probation department, the victim and witness protection authority, right? If it's going to be the presidential secretariat, then be it, So a lot of places where you are physically walking in with your client so that
Recording in progress.
I'm sorry, my computer talks, please excuse me. And these are instances where your client is confident enough to actually believe in the justice system, because right now it almost looks as if the system doesn't favor the victim, right? But we know as law students and as lawyers that the laws are in place, the systems are in place. It's just that it doesn't get properly implemented. So this is where our input and our knowledge is needed to actually get down to the grassroots levels, to get down on the field and to start working with the clients. And of course, you have to involve the government department. So, I mean, creating that safety network for children in Sri Lanka, talking about it wherever you go. So you're not just a lawyer. When you get into child protection, when you get into women's rights, you become what my late guru Jiva Samaranayaka said, but I also call myself a social working lawyer. So you're not just a lawyer, but you're also a social worker. And there are instances where I have just passed on my breakfast to clients who come from far away, who come in here, who don't eat, and then we have to take them to the police station. We are there for 4 or 5 hours, depending on the cases. So it is also that humanity aspect of this practice of this sacred oath that we take at the Supreme Court when we take oath as a lawyer.
Thank you for the inspirational introduction, Miss. Miss, this program is basically catered to the general public to simplify the laws. So, which is why we have a structured questions to go through it step by step. And we would like to begin with questions regarding adoption. If you can speak on what is adoption and how does the law define a child, because a lot of people don't know who a child is, what individual categorizes as a child. So if you can speak on that.
So now ideally the universal standard of the definition of a child is any person below the age of 18 years, right? So in Sri Lanka also the age of majority is 18 years. But in our laws, in different laws, the age of the child is different, right? So in our adoption laws, the adoption ordinance of Sri Lanka, a child who can be adopted. So a child means a person below the age of 14, right? I'll tell you why this has caused some issues. I'll also tell you what I think right now the government is doing about it. Before that, I'll tell you what adoption is. So adoption is very simply the process where a person who is not the biological parent of the child takes on the care, the custody, the maintenance, the control, and the education of a child who is not theirs, who is born to another person, right? And when this person, the applicant, who is the adoptee, takes on this child becomes as if born to the applicant biologically, right? So this is what adoption means, right? In Sinhala, you call it Kulavadagani. So in our ordinance, it says that a child can be adopted, a child below the age of 14 years can be adopted, right? Now, this has caused some issues practically, also few quite a few cases that have come to me as well, where children, when they're sitting for their O-level examination at 15 plus or 16, this is when they go to get their national identity card registered, right? So this is when some parents who have adopted the child at a very young age without going through the proper legal process, right? And some people who have said, no, no, we'll fix the birth certificate for you. This is the birth certificate. And they don't go through court and they take on the care of this child. At 16, when they go to get the national identity card registered, that is when the department realizes that this birth certificate is not original, it's a fake birth certificate. So at that point, we have had a lot of clients who have come and said, they're devastated and they're saying, my God, we got this child at 2 days. We've been having him or her for past 15, 16 years. Now we don't know what to do. The child doesn't know that he's adopted. Now what? Right? So in instances like this is especially for young lawyers and law students, we have applied to court through an adoption order, even though the age in the act is 14. Now our applicant's child is 16, right? We have and successfully got orders from court stating that, okay, these are the facts. The child needs to sit for the O-level examination in few months, right? Since the district court is the upper guardian of the child, please make an order taking into consideration the best interest of the child. So almost always the court has, considering the best interest of the child, granted that adoption order. And these are things that you can use when you're practicing as lawyers. But I must also say that now the Honorable Minister has appointed a committee to reform these laws. And there's an eminent committee with some super professional lawyers who are working on making actual change to these practical problems that we're having with the laws. So, of course, I personally believe that all the laws of Sri Lanka that refer to a child need to have that age limit of 18 years, because this is a universal standard of the age of majority.
Thank you, Miss. Miss, who can adopt a child? What are the qualifications can an adoptee have to be able to adopt a child?
Very interesting question. Okay. Because it has come into a lot of debate and argument as well. I'm going to just read you 4 words from the Act. Okay. Any person desirous of being authorized to adopt a child. Any person. Okay. So any person can apply to adopt a child, right? But there are certain prerequisites that are there. I will talk about these as well. So there is a general kind of belief saying, or whatever, stating that single parent people who have biological applicants who have biological children already are not allowed to adopt, right? Then there are these are just perceptions and things that have come out by word of mouth. People over the age of 50 cannot adopt, right? So these things are there, and I think the general public is extremely unaware of this, and they get advice from, like quack doctors, and they don't actually go ahead with it, right? But it is important to know that the law says that any person can apply to court to adopt a child, right? The only restrictions are that the applicant has to be over the age of 25 years. I personally think that's extremely reasonable. And the minimum age gap. The minimum age gap between the child and the applicant has to be 21 years, right? And also, there are unless, so there is a proviso to that The 21-year gap wouldn't come into account unless the child is a direct descendant, a brother or sister of the applicant. So that whole family kinship care that comes in, right? So there are exceptions to these rules also. But what you must keep in mind is the fact that the court will always take into consideration the best interest of the child. Now, that is a paramount consideration. If you take a lot of old case law, you take at least 10 case law, at least 9 talk about the best interest of the child being the paramount consideration, right? So these are the prerequisites. But otherwise, also there is one provision that says a single male applicant cannot adopt a girl child, right? I think the reasoning behind this section was because of the risk of safety to the child. Given that there is also a very high rate of boy children who are at risk by adults, mostly males. So maybe this is a section in the law that needs to be amended or thought about again.
Yes,
So
yeah, sorry.
No,
Go
so
ahead.
just saying that unmarried people can adopt. People over the age of 50 can adopt, right? People who have biological children can adopt. So these are perceptions that are within the society uh, that people talk about. But now, also to keep in mind is that once the application is made to court, there is a probation report called. So it is the probation officer is given a huge power here. The probation officer will interview the parties, will speak to the child, will go to the house of the applicants, right, to check their background and all that. So if that report is done properly, if that report is authentic, in that instance, that report is submitted to court, and the district judge will always take into consideration that report. But that is not the only thing he will take into consideration, but mainly the probation report.
Okay, Miss. Now, Miss, this may be a futuristic question considering the culture in our country, but however, does the sexual orientation of the adoptee matter when it comes to adoption?
Ideally, yeah. So now, like today, there was a big discussion when we said we're amending. I mean, we're talking about amending laws and establishing new laws. You should plan out at least for the next 100 years, right? So a lot of European countries, a lot of other countries who have legalized uh, LGBTQI marriages, right? So of course, in the future, these will also happen in Sri Lanka, right? So you need to keep room for all that. Right now in the law, like I said, any person can adopt. So the sexual orientation does not matter, and it is challengeable. You can challenge it, but again, there is a wide discretion that the court has, and there's a wide discretion that the probation officer has a power. So it also depends on that cultural mindset. You and I may not have that mindset, right? But it depends on the actors who are within that system and who are actually going to make the orders, and the people who will be part of that adoption order. In the UK, same-sex couples can adopt. It's part of their law as well.
Miss, can a foreigner adopt a Sri Lankan child, and is inter-country adoption happening today?
Yes, a foreigner can adopt a Sri Lankan child, and there are many foreigners who have. Um, they have started regularizing this, especially after situations that happened after the war and after the tsunami. So now this is very much regulated, but and it is handled by the National Probation Office. So just to let you know that local adoptions are handled by provincial probation officers and the provincial probation departments, but the the international adoptions are handled by the National Probation Office, and they have really regularized this. And there is also, I mean, it's part of our act. Foreign adoptions are also part of our act as amended as well. It does happen in Sri Lanka, but it will happen as a last resort, as in priority is given to local adoptions. And let's say, for example, there is a child that has been in the adoption list through the probation department for a very long time and is not being adopted by local parents or being taken in and then given back and so on, but there is a foreigner who is interested and all that foreigner's requirements are satisfied and so on. In such a case, the National Probation Commission department will look into those foreign adoptions.
Miss, what happens if a Sri Lankan who has been overseas for, say, 20 years, for example, and then will that person count as a foreigner or a Sri Lankan when it comes to adoption then? And if he has a dual citizenship or in such scenarios?
It depends on their visa status and their citizenship status, right? So if they have citizenship in Sri Lanka, they can always come down to Sri Lanka and go through the process as a local applicant, right? But if they do not have citizenship in Sri Lanka, if they have given away their citizenship, then yes, they are considered as a foreign applicant. Let's say, for example, they want to adopt, say, the sister's child, or a relative destitute child, right? So in that case, again, the National Probation Department will come in, look into the facts of the case, and take on that adoption. If it is in the best interest of the child to be adopted by that foreign applicant who is nationally, who is a Sri Lankan or who was a Sri Lankan.
Miss, since we have the sorry, yeah, go ahead, Miss.
Let me just point out on one thing. There are some people who have a good life here in Sri Lanka, but want to send their children to another country for education, right? So the visa process and the expense for education is a bit high, right? So they try to take the loophole of getting a relative in that country to adopt the child. Because if that relative is a citizen in that country and this child is adopted, then the education and schooling and everything is free, right? This is a loophole, and this is actually a problem that I think the department is currently facing with what to do. Because it's almost like a cheating the visa system by our country. So this has serious concerns. I mean, even I recently got a client who is extremely wealthy, but didn't want to go through that process of the visa and the education, which is going to cost about $10,000 per year, but rather let his sister adopt his child. Okay, which I didn't take on.
Miss, can you speak of the process that needs to be followed in order to adopt, and what are the monetary requirements for adoption?
Okay. So there are two ways with regard to the process. First is through the probation department, and second is private adoptions, right? So the first way, through the probation department, if you have these prerequisites that I told you about, you're over 25 years and so on, and you go to a child development center, you have seen few children, you can't choose your child, but you go and then you register yourself in your area probation office, So every province, every district, every divisional secretaries have their probation officers. You go and register yourselves. Then there is an interview done by the probation officer. So basically, where you need to submit your Gramanidari certificates, simple things like what you do for a living, whether you have any criminal records, just a very basic conversation that the probation officer is going to have with you with regard to what you do, why you are eligible to adopt, why not, and whether you have any medical issues. I mean, there are also parents uh, who have issues medically trying to give birth, and that is why they want to adopt, and all these reasons. So once that you are registered with the department, you are put on a waiting list, right? And they will find a suitable child who is also on the adoption list, right? So in this instance, what the probation department concentrates on is a family for a child and not a child for a family. So that is a saying that was stated by a scholar, and it is also in the implementation handbook of the UNCRC. So what the probation officer wants is a family for a destitute child rather than a child for a family. I hope you get what I mean, right?
Yes,
And
yes.
so then they will look at the children who are up for adoption and say there are 10 people on the list, right? In the waiting list. And there are also, 5 or 6 children, because it's always there are more applicants than children, right? So they will look at the best applicant for a certain child. So it may be you, me, and another person as applicants. Maybe you are better educationally qualified. Maybe you stand at a better job and monetary place. Money is not the only thing, but also that whole concept of family. Maybe you are at a better place than I am. So then the probation department will give child A to you. Thereafter, the case is filed in court, right? And the usual process of adoption through the act is taken forward. So the party's application is forwarded to court, right? Thereafter, the probation reports are forwarded. Then there are affidavits and so on that the applicants need to file. There are probation reports that need to be filed. If there is a biological parent alive and in touch, so if the biological parent is available, then the biological parent's consent is needed. That is part of the law. But of course, if the biological parent has left the child, has abandoned the child, or is of unsound mind, or is not in touch for the past amount of years, then that consent can be dispensed with. Otherwise, the biological parent's consent is needed. And after the probation report is called in, then the court will have an inquiry for the applicants, and if the biological parent is there, then the biological parent as well. And thereafter, final adoption order is given. After the adoption order is ordered by court, then order is sent to the Registrar General's office, where the applicants have to go and get all the birth certificates and so on. So that is the procedural process with regard to the birth certificate and all that.
How long does
I
this
think you
whole
asked me another
process take?
question.
Uh,
Okay, so
and the money.
I think you asked me about monetary. Yes.
Yes.
So monetary requirements. Yes. Ideally, it is the fees that you pay a lawyer to appear in court. So like a normal lawyer who appears, a civil lawyer who appears in district court, whatever that lawyer pays. But otherwise, it is illegal to have any sort of monetary or by way of gift or anything in the process of adoption. You can't pay a biological parent, you can't pay a probation officer, you can't pay anyone in the who plays the middleman any money. That is, of course, a breach of the law. right? And can even amount to child exploitation and these baby farms and so on.
Miss, how long does this whole process take?
See, it depends, right? In cases where there was there is a biological parent, and if that biological parent quickly gives the consent, comes to court for the inquiry, and the probation goes to the probation office for these interviews and so on, then maximum 1 to 1.5 years, your case is done, right? Because the thing is, it also takes a while for the probation officer to submit the report. I mean, these are extremely under-resourced officers. Uh, uh, with regard to simple things like A4 sheets, also they're extremely under-resourced. So due to reasons like this, their reports also get delayed, and they have an overwhelming amount of cases that they need to make reports on a daily basis. So there is a delay within the department itself to submit reports to court. And of course, this pandemic has caused so much of delay. One of my clients is now going on year 2 of the adoption process. The child is already 2.5 years old. So this delay in the system is what causes. But otherwise, I mean, the applications, the coming in for inquiries and so on. Ideally, it is a case that can be finished in about 6 months to 1 year. But because of the pandemic, one reason, and also because of delays that happen with regard to this reporting. And it can also happen because of the biological parent who refuses to come to court sometimes, who doesn't have Gramanidadari certificates, who doesn't have ID. These are practical problems I'm talking about. And so on. So these are the delays that can actually happen. I also didn't mention the second type of adoptions, which is private adoptions. So this is where, say for example, somebody comes and gives you a child, Zenat, and says, look, I don't want this child, here you go, bye bye, right? So at that point, you run to a lawyer, and then you file a court case saying this person doesn't want this child and I want to adopt this child. So then this is not through the probation department and not a child who is already in a child development center, but a private person who has come and said, look, I don't want my child, I'm willing to give up my child on adoption to you, right? So then there are also the same documents, the applications, the affidavit from that biological parent who doesn't want the child anymore, and so on. And you file a case in court, and the act provides for an interim order. Interim order is as soon as you go, you make the application within the second or the third or court hearing, you can ask for an interim order until this case is over. Can I have an order to keep the child with me, right? So these are also very important things that people need to know. So just because somebody comes and gives you a child with a letter signed on top of a stamp, just go into meet a lawyer and take it through the legal process, which will help you, the applicant, and also that child with the child's education, medical needs, and so on. So it's very important that it is taken through that process.
Miss, you mentioned
Yeah.
probationary report. So I think there are a lot of people who wouldn't know what a probationary report is. Could you explain it in simple terms, what it contains and what they have to expect in a report, the probationary report?
Yeah. So child adoptions and the care and protection of children is handled by the National Probation Department, Probation and Child Care Services, and something else department, right? Like I said, there's a national department and also divisional provincial departments, right? So the probation officer is given the task to monitor the welfare and the care and protection of the child, right? So Ideally, in other countries, it's done through the Women and Children's Ministry welfare sector, and it's called a social welfare officer or so on. That's what it's called in Singapore. But in Sri Lanka, it is a probation officer. The name itself gives a kind of a, what do you say, in the USA, probation officers handle young offenders, right? But in Sri Lanka, our probation department handles the care and protection of children in general. So a probation report is called on an applicant, right? So the probation officer has a duty to submit a report to court, right? So it will say, Zenith is blah blah blah. She's married to such and such year-old man. Both of them are living together. They live in this house. The house has 8 doors and 25 windows. It is tiled. It looks like a safe environment for a child. Zenith is a lawyer. Husband is a lawyer. Okay. Both of them earn this much of money. They seem to have no bad records. House seems to be child friendly. Both of them have good medical records and so on. And in the final part, they will say, we recommend this couple to be a safe couple to adopt a child. And අධිකරණය අභිමතය පරිදි සුදුසු නියෝගයක් ලබා දෙන්න. And this report will be submitted to court. And then the court will decide. But let's say they go to your house. Okay, let's go to somebody else's house. Okay. And as soon as a probation officer walks in, they see a man doing drugs in the middle of the house. Okay. They see a lot of bottles of alcohol, a lot of drugs all over the place, extremely messy house. Maybe they even witness some domestic violence happening between the parties and so on. So that they will report to court and they will say, I don't recommend it, but since you are the upper guardian of the child, you make a appropriate decision. So I must say that the court does take into serious consideration the probation report.
Is there a psychological evaluation of the couples as well to ensure that the child is going into safe hands?
Unfortunately not. Unfortunately, Sri Lankan law does not provide for that. But like I said, there are committees appointed and these things have come into serious discussion because I have been studying the adoption laws of the UK and Singapore. And the Singapore adoption laws are the exact same as ours, except that they have a pre and post psychological service available to the applicant and to the child. UK has this as well. So these are best practices in other countries that I feel we can use in Sri Lanka, because I think now mental health is discussed quite a lot. And this whole adoption process is an area where a lot of mental health assistance is needed. So unfortunately, right now, it is not available in our laws, but I hope the reforms see the light of day and, we can actually make it part of the laws.
Miss, can the adults have the option of choosing a child, or is it done by the authorities? Can they have the choice?
So no, you can't choose a child. There are certain instances, very difficult to. I'm not getting the word here, but there are Sri Lankan mindsets who go and ask for මට සුදු ළමයෙක් හොයලා දෙන්න. ඒ ළම කළුයි නේද ටිකක්. Okay, so skin color matters. So these are the reasoning behind the department not allowing people to choose children, because the kalu lamaya will never get adopted in that case. But you can go to a child development center and you can say, there's a list of children who are listed to be adopted. So you can go and take a look at all the children and say you can say, okay, these children, but that won't it's not really hard and fast. So you can't really choose, okay, this is the only child I want. But you can say these few children are available. Okay, can you consider these 3 children for me? And then when the department is actually going to do it, they will look at who is the best parent for this child. So I think the department chooses the parent rather than the parent choosing the child.
Miss, is there a number limit on a couple adopting a child, like maybe just 2 children or 3 children? Again, is it like in the best interest of the child, is it?
Yeah, it also depends on the best interest of the child, and there is no number limit. It's not part of the law. It's not in the act. I know a client who is now almost finished their second adopted child. So I don't think there is a number limit unless there is a special regulation made by the department. But I am unaware of such regulation.
Okay, Miss. Miss, do people make money by acting as a middleman in the process of adoption? Can we talk about that as well?
We talk the truth here. I think people do, right? But I haven't come across any. And the law says that you can't make any money, so it is illegal. But frankly, I think it does happen. And I don't know how it can be regulated also, especially with private adoptions.
Okay, Miss. What happens to rights of biological parents? Can a child who was adopted inherit the property of his biological parents?
If the final order is given, okay, once the final adoption order is given, the biological parent loses all rights to the child, right? Likewise, the child cannot claim any property rights or assets from the biological parent after the final adoption is made. But the child can, of course, is a heir to the applicant, as if the applicant has had a biological child. So the adoptee is liable to make the child a part of his assets or whatever upon his death or whatever, but not the biological parent after the final adoption order is.
Okay, Miss. Now we'll move on to questions regarding custody. My other committee member, Shalomi Thassen, will take over the questions.
Okay.
Shalomi?
Thank you, Zena. So since we discussed about adoption in great detail, I would like to start off on custody by asking what is custody and how it's different from adoption?
Okay. So custody is when there is a dispute between biological parents with regard to the care, protection, ownership, education of a child, let's say at a dispute of their marriage, right? So custody is when who has that care, protection, ownership, education, and those rights of the child, right? So, for example, adoption is when either the biological parent does not want the child anymore and somebody completely different who has no kinship even will take on that care and protection of their child. That is adoption. Custody is when there is a dispute between biological parents so as to this care and protection and placement of the child. So custody orders come within, the procedure comes within the Civil Procedure Code. And again, as always, it is the best interest of the child that is always taken into consideration. I can't hear you.
Sorry, madam. And we often heard the terms joint custody and single custody. So what is joint custody and what is single custody?
So ideally, at a point of, let's say, divorce or annulment or a dispute within the marital status of the parties, and that final order is given, you also ask for the custody of the children. In an ideal situation, what happens is custody is shared amongst the parties 50-50, right? So 50% of the legal custody to the father, 50% of legal custody to the mother, 50% of physical custody to the father, 50% of physical custody to the mother. So joint custody. Or it can be 50-50 legal custody and mother gets physical custody and the father has access rights, right? So, for example, mother will have the children from Monday to Friday, and the father will have the children from Friday to Monday. That would be a situation of joint custody, right? Say, for example, also in one of my cases, where the father is extremely abusive. He is a uncontrolled substance abuser and causes a serious threat to the safety of the children, right? In such a case, you can ask court for the 100% physical custody and 100% legal custody to this mother, right? And there are cases where this has been successful. So that would be a single parent custody situation, taking into consideration the extreme risk to the health and safety of the children. But say within a year, this father cleans himself, he goes into rehab, he becomes a good person, and so on. Then you can apply to court again, saying that, look here, there has been a change of circumstances now. I've cleaned myself. Can I have access to my children, or can we change these custody arrangements? And that too, through the Civil Procedure Code, mentioning to court that there has been a change of circumstances, can be changed, can be applied for, and the court, as the upper guardian of the child, will again take into consideration the best interest of the child and make an order. I want to, right now, since we are on that, I want to read to you a statement from Justice Tilakavardhana in a case called Jayarajan versus Jayarajan, right? It's very interesting. Courts should look for cogent and substantial evidence to effect change in the life of the child, especially in the light that she had for more than 2 years not even seen the petitioner. The person who have acted as parents where she is concerned have been her maternal grandmother and her mother. It is in this home that the child's sense of security has been built upon. So she has taken into consideration the child's sense of security. This is the responsibility that the court has to take and to ensure.
Thank you, madam, that detailed explanation. And you were talking about the legal custody and the physical custody, madam. So can you explain that for the general public?
So legal custody is, of course, as the name says it, when the legal requirements are needed. Let's say, for example, signing off important documents or passport applications. If the child needs to go abroad, let's say for a netball tournament, right, and a passport needs to be applied for, then in such a case, both parents have to consent to the child obtaining a passport. Or let's say the person who has the physical custody wants to take the child somewhere on a trip out of the country. So in that case, then the consent of the other person is required. Let's say there is a, God forbid it won't happen, but there is a serious medical need that the health system needs a signature, right? So in that case, it's a legal requirement. School applications, but also now single parents can apply and giving children to school. But all these legal requirements, let's say property issues and so on, if a child is a beneficiary in a trustee and there are certain things that have come upon that property that need to be decided. So these are all legal requirements that need the consent. Then that is what is called a legal custody of the child. And the physical custody is, of course, physically where is the child going to be placed. Is the physical custody of the child going to be with the father or the mother or the grandparent, right? It all depends on circumstances of each case.
Thank you, Madam, for that clarification. And my next question to you is, Madam, how do courts determine on who's going to get the custody? Like, is there a criteria by which the courts go by? Is there any criteria to determine that?
Yeah, so I mean, the procedure is laid down in the Civil Procedure Code, but the criteria is almost, if you take 100 cases, general laws, it is the best interest of the child. So in many of the past cases, it is stated that, I mean, Sri Lanka has a fault-based divorce system, right? Fault has to be placed on either party. Even if they're mutually agreed to a divorce, somebody has to take on the fault for the divorce to get a final order, right? So considering that, a lot of the past judgments that I've read, it says that that it doesn't matter whose fault is it at the divorce, right? The court will only take into consideration the best interest of the child, right? So, like I just read out in Justice Tilakavardhana's judgment also, the security of the child, the safety of the child, the health, education, so on. All these needs are taken into consideration when the court decides on who gets custody. It doesn't matter. So, I mean, say for example, the father has the fault-based system says that the father has acted in adultery, and that's why this divorce is happening, right? And on the other side, let's say the mother is mentally unwell, of unsound mind, and she has physically caused damage to the child, right? So in that instance, the court will weigh the pros and cons, right? The court may grant physical custody to the father, right? But also maybe a grandparent as well. Okay. So it, like I said, it depends on each case and the facts and merits of each case, and also how the parties put in their arguments to court.
Madam, as you mentioned your explanation, there might be like exceptional cases where both parents are not fit to have custody. So in those circumstances, what will the court, how will the court determine who gets the custody?
Ideally, I mean, if the child is lucky and there is somebody with a blood relationship, kinship, who will come forward, like a grandparent and so on, who will come and say, look, I am willing to take up the custody of this child, then in that case, custody will be given to a grandparent. But otherwise, as a last resort, the child will be placed in a child development center under the probation department.
Okay. And what is meant by best interest of the child? Because we've already talked about it. So yeah, can you clarify?
So best interest of the child is guaranteed by the United Nations Convention of the Rights of the Child, which Sri Lanka is a signatory to, and also through our ICCPR Act. Okay, so the best interest of the child. Law students and young lawyers memorize this. Best interest of the child is a paramount consideration. Okay, those few words are very important, and every state actor who is part of this whole child process, whatever it may be, has to take into consideration the best interest of the child. How it is defined is, it is not the only consideration, it is a paramount consideration. So that is the weight upon this best interest is put in. So best interest of the child ideally should be the interests of the child with regard to age, gender, maturity, right? Then any other characteristics, the child's physical and emotional security. Okay, so like I say, again, I'm going to refer to this judgment where she says that that is where the child has been secure, right? So if, let's say, for some reason the child is removed from a place where he or she felt extremely safe for the past 5 years and comfortable, there's been a routine, mental health is fine, and removed and placed in a completely different place where they need to adjust again, that is not considering the best interest of the child, right? So it is all this whole need of development through the psychological perspective of the child, also the physical and educational. But now people talk about, like I said, people talk a lot about the psychological needs, the mental health assistance, and also children with special needs. And I mean, now with regard to, like I said, there are, the minister has appointed so many committees, and this best interest of the child is spoken about, and there are special professional stakeholders who come in for these meetings, like child psychologists, child psychiatrists, who actually talk about even things like daily routines of the child, the school, access to the school, access to whatever extracurricular activities they are doing, right? And then the environment in which the child has been residing. Let's say, for example, it is a child who has been living in a big area of land, climbing trees, running around, riding the bike, and so on. If this child has to be changed, if he has to change places into an extremely cooped up apartment, for example, it's a very simple example I'm using, this may affect the psychological status of the child. So these are things that need to be taken into consideration when the court considers the best interest of the child. And hopefully, the laws will provide for these, hopefully very soon.
Thank you, madam, for that clarification. And also, if a parent has custody, can she or he claim maintenance?
Absolutely, yes. So whoever is capable of providing financial assistance, then the other party can always claim for maintenance through the whole the divorce custody order as well. This is also the procedure laid down in the civil procedure code.
And my next question is, madam, can the child decide which parent to live with? Does the child have a say on it?
Yeah. If the child is over the age of 10, the law provides that the court can ask the child. But the child's opinion is taken into consideration. But it is not the only thing that is taken into consideration, right? Because children can be coaxed into saying different things. So one thing that lawyers can do is ask court for a psychological assessment or a psychological report to be submitted to court, and also then speak to the child also and get the child's opinion as well, because it is extremely important. If the child is going to be questioned by the judge, I mean, these things are done in chamber, it's done in private, the judge is very casual, speaks to the child with regard to this, but it is a process, it is a legal process that adults are taking the child through. So in such instances, it is my personal opinion that children need to go through a psychological assistance process if they are taken anywhere near our court system.
Thank you, madam, for that explanation. And what is reasonable access and who can claim it?
So access is also again depends on each case, right? We have one of our cases where the father is a driver who drives in the night, but also, hold on please. who is also addicted substance abuser, right? In such an instance, then, but because he's a biological father, he has access. So in this particular case, this person was given 4 hours access once in 2 weeks, right? But there are other cases of, 2 days per week for one parent, 5 days per week for another parent, right? So the reasonability of it depends upon the parties, right? In some cases, parties come into a settlement. With their work routines and whatever other relationships they have and their social life, they themselves come into settlement and say, okay, you keep him for these days, I'll keep him for these days. So if that settlement is also signed by both parties and signed by the lawyers and submitted to court, then it will be as per settlement. So again, like I said, depends on each case. Who is eligible for access are the parents who are in dispute.
Thank you, madam, for that explanation. And also, generally, what is the time duration to grant custody in any custody matters? Is there a time duration?
There is no time duration in the law. Within 2 to 3 hearings, you can get an interim order, right? The court will grant an interim order saying, okay, legal custody to both, physical custody with the father or the mother, whatever, right? But until the final order, again depends.
It's 19 hours.
Again depends on each case, because if they decide to contest and be extremely bitter with each other, it can go for the next 18 years until the child is at the age of adult, right? But if the parties, like I said earlier, if they come into a settlement, then maybe 1, 2, 3 years, depending on the circumstances of the case.
Madam, what is emancipation? Can a child be emancipated according to the Sri Lankan law?
The Sri Lankan law on this is extremely unclear, right? And as per the Civil Procedure Code again, section 502, it says that a minor shall be deemed to have attained majority or full age on his attaining age of 21 years, this was now amended to 18, or on marriage, or on obtaining letters of venia aetatis. Okay, now I will explain to you what venia aetatis is, a Latin term. The privilege of age sometimes granted a minor under the Roman or civil law, entitling the minor to the rights and liabilities of a person of full age and resembling emancipation in modern law, right? So according to our law, this has been mentioned with the reports to the Committee of the Rights of the Child, where it states that the acknowledging of the age of majority ordinance, right? But now our age of majority is 18, right? And I have done some research on this, and Sri Lanka's law with regard to emancipation is extremely unclear, right? In one of the committee reports to the committee on the one of our reports to the Committee on the Rights of the Child say that Sri Lankan law recognizes the concept of tacit emancipation, according to which permission granted by a parent to a minor child to carry on a business and live on his or her own confers legal capacity for certain purposes and contractual capacity and liability. So this is as much as I could find on emancipation here in Sri Lanka.
Thank you, madam, for that detailed explanation. Moving on to the child protection, the questions related to child protection. What is child protection and the role of the laws and the institutions related to child protection? Can you explain a bit about that, madam?
Yeah, so child protection is, of course, when we're talking in the perspective of the law, protection is with regard to children who come into the system and thereafter their protection. So a child comes into the system as a victim of offense or a child who has been accused of offense, right? And it is the responsibility of the state Okay, you and I being citizens of the state, yours and my responsibility also to create that safety network for children, right? So basically, that is what child protection is, to have a child's needs, uh, and for a child to be secure within an environment that the child lives in, right? The role of the laws and the institutions, our laws are, I believe that our laws are in place, except for, few, like I said, a little retweaking in the system. But the implementation is, as I see, our biggest problem. So all our institutions relating to children, starting from the police department, the medical department, the judicial medical officers, the pediatrics, and child psychiatrist units, then the probation department, the National Child Protection Authority, right? Legal Aid Commission, people like you and me, and the general public itself have a responsibility to create that safety network for our children.
And how can the youth in Sri Lanka help in eliminating the violence against children? What's your take on it? What do you think that they can do?
I just got shivers down my spine for that question, because I believe right now the youth are the change makers in our country. I have two legal researchers with me who are 20 years old, who are the most efficient workers in my office. And when you talk to them, the ideas that coming out of their mind, maybe give me 5 minutes, okay? We are hungry. 5 minutes. The ideas that are out of their mind, the ideas of people like Zena, that whole wanting to change, this needs to change. We need to create this network for our women and children, to create this whole strength of the family unit, and that safety network is amazing. And the youth in Sri Lanka just keep going, right? But other than that, also have access to learning things about laws. Hold on 1 minute, please. Have access to learning, talk about it, like what you're doing today. You're spreading awareness to the public about laws available, systems available, people who are available to have access to if you want to do something. Yeah, so I think the youth just need to keep going and do what they're doing, keeping in mind to gain more knowledge on what you're interested in, on child protection, what are the best practices in other countries, and so on. And don't just gain the knowledge and keep it for yourself. Gain the knowledge and spread it to every community. So if you're going in a bus, talk to the person next to you. If you're standing with a security guard, talk to him about child protection and the importance of it in Sri Lanka. I do it. I speak to everybody about it. So, I mean, be it a security guard, be it the top level businessman, be it whoever I meet, I talk about it just so I can create awareness. There is a massive amount of people who don't know. So knowledge is, wealth. So we need to just keep spreading it.
Thank you, madam, for your very comprehensive and detailed explanation. You have covered some of the most complicated issues and simplified the legal matters for the general public. And as a part of the next part of this discussion, will be discussing the online questions, the questions we received from our online participants. Zeenat will take over.
Thank you, Shalomi. Miss, we have sent out a Google form prior to this session where we ask the public to send in their questions. And also we have questions from the audience who are joining us live today. One of the questions is, do parents have to be less than 40 to be able to adopt a newborn, an infant? Is there an age restriction?
So like I said, the law doesn't provide for that age restriction. there is a minimum age limit in the law, which is 21 years old, but the law has not yet placed a maximum age limit, right? So if a 40-year-old applies for a newborn, this is where the probation report comes into consideration. The probation officer will look into the best interest of the child. When the child is 15 years or 20 years, when the higher education is finished, will this parent be fit enough to provide, and so on, whether the parent has any health issues, and so on. So these are things that the probation officer will take into consideration. But no, the law does not say that a 40-year-old cannot adopt an infant.
The other question is, I'm an ex-Sri Lankan but hold a resident visa which has to be renewed every year. I'm moving back to Sri Lanka. Is it possible for me to adopt a child? Will dual citizenship holders have the child automatically get dual citizenship?
So, like I said earlier, again, if they're resident in Sri Lanka, if they hold citizenship, they can apply as local adoptees. But if they don't hold a citizenship, then they have to go through the foreign adoption process. Did I answer that? Yeah.
Yes. And regarding the dual citizenship, like if the parents have dual citizenship, will the child automatically get dual citizenship?
I think that's with the visa laws, but I think you have to apply for it.
Okay, miss.
I'm not thinking.
There's another question. Can a child be adopted not from a child center, but from a community? We are US citizens and dual citizens now. I think they're referring to a US law, no, miss?
From a community, as in if it's a Sri Lankan community, if there is a parent who is willingly giving away their child to you, then a private adoption process can proceed in Sri Lankan courts. But if you're a dual citizen, you can come here and take it on as a local adoption, wait till the adoption proceedings are finished, get the final order, and thereafter move back if you want to, live in beautiful Sri Lanka if you want.
The next question is it possible for a single parent to give away an illegitimate child for adoption without the consent of the other party?
If the other party is in contact, if the other party's name is in the birth certificate, or it depends, then the consent of the other party is needed. But let's say, for example, the other party cannot be found, and the other party has completely abandoned this child, then no, the other party's consent can be dispensed with. And it happens most of the time.
Okay. Is there a hotline anyone can call if they see a child being abused?
Absolutely. So 0112 444 444 is the Police Women and Children's Bureau head office, and I have found them to be the most efficient. Or 119 if you can get hold of them over the phone. 1929 is the National Child Protection Authority hotline. And also there are a lot of civil society organizations like Child Protection Force, Grassroots Trust, Bakamuno.lk, Emerge, Care Station. A lot of these civil society organizations who have also now become first responders to these situations. They will also direct you to the towards a proper legal process of complaining and so on.
Thank you, Miss. We've come to the end of the discussion today. We would like to move on to the vote of thanks. Anjali?
Thank you, Srinath. So I think it was a very fruitful session. So on behalf of the Pro Bono Committee of Law Student Association of Sri Lanka, I would like to thank our speaker, Ms. Milani Sarpitikorala, who clarified the questions and doubts for the general public by her very comprehensive and detailed explanations. So we express our gratitude to ma'am for being the part of the discussion and for helping us to make awareness on this much needed topic. And then we would like to thank our media committee for their technical assistance throughout the whole project. And last but not least, we would like to thank our online participants who are very active today, who are engaging in the discussion very actively by sending their questions. So we invite you to join us. We'll be having a lot of programs in the future as well. So yes, that's it. So have a good night. Thank you.